still this morning, so good morning. We thank council for your flexibility. This time we'll call the next case, which is State versus Rowdy. We'll hear from the appellant.
Thank you, Your Honor. Good morning. May it please the court. My name is Steve Fuller. I represent the appellant, Mr. Rowdy, in this matter. The question that this court has approved for review is what is the appropriate legal test when assessing whether the odor of marijuana gives rise to reasonable suspicion or probable cause. All we are asking for today, Your Honors, is a turn to the default test of totality of circumstances that we learned at the beginning of law school. We submit that the totality of circumstances test is appropriate because the rationale for odor alone has been destroyed that arose from State v. Greenwood. Under State v. Greenwood, only if an officer was sufficiently trained to identify marijuana at an expert level was that officer then allowed to testify that they indeed smelled marijuana, and that testimony was sufficient to give rise to probable cause for a warrantless search. Today, stores in every county of North Carolina sell industrial hemp products. Both deputies in this case testified that industrial hemp and illegal marijuana look the same and smell the same. The SBI memo that was issued to the General Assembly stated that illegal marijuana and legal hemp look the same and smell the same. In that memo, the SBI also warned that if officers came across vegetable matter consistent with marijuana, then they would lack the probable cause to seize that evidence, and therefore officers and prosecutors would not be allowed to prosecute marijuana cases in the state because of that holdup. Basically, the memo argued that marijuana would become de facto legalized. So in that memo, the SBI urged two possible courses of action for the General Assembly, one of which was to limit the types of hemp that could be grown in the state and sold in the state. And that would limit the types of hemp so that smokable hemp would not be out in the public. The other suggestion in the SBI memo was to redefine what is illegal marijuana under the general statutes, and the legislature chose neither course of action.
So the Court of Appeals in this case, unlike in the other two cases we heard earlier, I think said in this case that the legalization had no impact on the applicable test. I think the Fourth Amendment jurisprudence is what they said. Because, and then they emphasized this idea that you're only looking, this came up in some of the early arguments, that the fair probability, you don't need to know for certainty, and that there's criminal activity afoot. So I think what you could infer from that is that what the Court of Appeals, at least in this panel, believed the rule should be is that there is no per se rule, but that officers, through their training and experience, when smelling that odor can say, I think there's a fair probability that this is the contraband, not the potentially legal alternative, and therefore I have reasonable suspicion or probable cause. I guess my first question is, do you think, am I understanding what that holding was correctly? And if so, I assume you have something wrong with that. What do you think is wrong with that?
Well, I believe that Can you repeat the question, Your Honor?
Yeah, so basically what I was saying is I think the Court of Appeals in this case may have been doing something the other two panels did not, which is saying we're not saying that there's a per se rule that automatically if you smell the odor of marijuana, it amounts to probable cause or reasonable suspicion. What this panel will be saying is that legalizing hemp doesn't change what we've always been doing, which is if in the training and expertise of this particular officer, if they are looking at the totality of the circumstances, which happens to be in this case, I'm smelling this odor that through my training I know is connected many times to this illegal activity, that can support, in the officer's view, reasonable suspicion or probable cause, or in that particular fact scenario, and that so it may not be a per se rule, but that, in other words, there are times it is possible that the odor of marijuana alone can still be enough to create reasonable suspicion, probable cause. So, which I don't think is something the other two cases said. So I'm just asking you about that.
Well, Your Honor, I would submit that the issue comes down to that expert level certainty of what the odor is that the officer believes they're smelling. And because of the change in laws, that same level of certainty does not exist anymore. And so that is baked into the reasonable suspicion and probable cause analysis, and that no longer exists with the current laws in North Carolina.
But
Yeah,
again,
so go ahead.
no, go ahead.
I mean, I think there's a little bit circular, because what I was getting at is the Court of Appeals may have understood what you just said and rejected that argument. So in other words, rejected the idea that the basis for saying this odor can lead to probable cause is that the only source of the odor could be that it's contraband. And the reason I say that is because the sentence, or two sentences before it, they said, we don't think the legalization of hemp has any bearing on the test we're applying. And then it's when they said, because you don't need to have a certainty, you just need a fair probability, knowing that there's this use of a product out there that leads to this very distinct smell that is a criminal activity. When you smell it, an officer can have a fair probability that there's criminal activity afoot. And I'm asking you to sort of, I assume you don't agree with that, but why is that wrong?
Your Honor, I'm sorry if I'm missing the response here, but our understanding is that the ability to testify that this is indeed the smell of marijuana arises from a landscape of law where that was the only common occurring substance that had that smell that would be found by police during investigation.
Right. What I'm getting at is the only thing I can understand about what the Court of Appeals is saying here is that the inference, I think, is that what they're saying is, are there some people that smoke legal hemp? Yes. Not as many as smoke marijuana. You don't get the same benefits, sort of you pharmacologically or whatever for smoking the hemp that you do from the marijuana. In my experience as an officer, I'm not encountering a lot of people smoking legal hemp. I'm encountering lots of people smoking illegal marijuana. And therefore, when I smell this odor as an officer trained, that creates the fair probability that it's the criminal activity. So that odor alone can still be enough. And I'm trying to understand, because that seems to be different than the theory in the other two cases we talked about. So what's wrong with that theory if that's what the Court of Appeals was doing here?
Your Honor, I believe that just misunderstands the state of play that's in North Carolina at this time, where there are hemp stores in every county in the state, and there are several within walking distance of this courthouse that takes into consideration facts that are not in the record as to the level of prevalence of industrial hemp that's in marijuana or the pharmacological effects of using industrial hemp. And so the General Assembly chose neither of those options that were laid out in the SBI memo. And so the probable cause standard that the state is asking for today in general terms is if an officer detects a fact, and that fact implies an unknown probability of either a legal activity or an illegal activity, then the officer necessarily has probable cause to search for that illegal activity. Marijuana laws have been changing across many states in this country, and many states have been reckoning with considering a change to the odor alone rules in their states. And so I would offer a couple of states, for example, for guidance for this court in reaching its decision today. And the first of those is in the state of Pennsylvania. I cited a case, Commonwealth v. Barr, that was in the brief. And in Commonwealth v. Barr, Pennsylvania was reckoning with a legalization of medical marijuana that had happened. And so in that case, the court looked to the issue of carrying a concealed firearm as an analogous situation. In both situations, in medical marijuana and in carrying a concealed firearm, It is a legal activity if you are a license holder. And so in a case called Commonwealth v. Hicks that the court and bar looked to, officers had surveillance footage of the defendant carrying a concealed firearm at a gas station. Officers seized that defendant at gunpoint. In the case in Hicks, the court held that officers did not have reasonable suspicion to apprehend the defendant in that case, even though they had a clear sight of a concealed firearm. And that's because the sight of the concealed firearm does not per se mean it's contraband. It may be legally held as a license holder. And so what the court in Commonwealth v. Barr did was they relied on that logic from Commonwealth v. Hicks and held that the sight or the aroma of marijuana alone is not contraband. And so that factor alone does not give rise to probable cause. Another example state would be the state of Illinois. And that was a case called People v. Redmond. And in Illinois, the court there was reckoning with recreational marijuana being legalized. There, the court looked to the odor of alcohol as an analog to the odor of marijuana. Both substances may be legal, may be illegal, depends on the situation. And so in People v. Redmond, the court looked at past cases concerning the odor of alcohol, one of those being People v. Smith. And in People v. Smith, the officer approached a driver. There was an odor of alcohol emanating from the driver in the vehicle. He looked inside the passenger compartment and saw what appeared to be a Miller bottle poking out of a brown paper bag and with liquid inside. And so with that odor of alcohol and with the open bottle, the officers did have probable cause for a search to find evidence of having an open alcohol container inside of a vehicle. The court then contrasted that case with a case out of Kansas called State v. Stevenson. And in State v. Stevenson, similarly, the officers approached a driver. There was a smell of alcohol. The officers looked for open bottles inside of that car. They did not see any. They ordered the driver out of the car, and they had him perform a field sobriety test, which he then passed. And so with those factors combined with the odor of alcohol, the lack of bottles inside of the car, and the passing of the field sobriety test, those factors tended to dispel the suspicion, and there was no probable cause for the search in that case. So the court in Illinois and People v. Redmond used those holdings to hold that totality of circumstances test is what's appropriate when officers have the smell of marijuana.
May I follow up with these two cases and help me understand how to reconcile them, both the Pennsylvania case and the Illinois case? The small quantities of marijuana was actually legal in those states. We do not have that rule here, our law here. Ours is simply the hemp that's been in front of us today. How do we analogize with that difference, that difference? And it may be that your colleague on the other side might point to that.
Yes, Your Honor. Well, I would submit that at least in this way, and that what was once a near-level certainty from the smell that there's contraband present, that no longer exists because of a change in the law in the state. So in each situation, whether it's medical marijuana or recreational marijuana or industrial hemp, the officer in the field, all they're immediately privy to is the smell of marijuana. And is that one fact alone enough for a reasonable suspicion or probable cause? So it's that scenario that the law enforcement is facing. They don't have the certainty that they used to have in the 80s and 90s about this issue. The state submitted...
but to go back to
yes.
a point made earlier, and hopefully not ad nauseum, but that word certainty keeps coming up, but certainty is not required for probable cause. So help me understand why the fact that they can't be certain anymore that it's contraband means there's no probable cause.
So underlying the testimony that an officer is smelling marijuana is that they've been trained to an expert degree in being able to identify that this particular smell means marijuana. With the advent of industrial hemp, that level of expert certainty is not there anymore. And so it's not conflating probable.
But do they have to be certain that it's contraband to have probable cause?
They don't need to be certain that it's contraband to have probable cause, but to have the expert opinion required the level of expert training that, and maybe they're incorporating, there's no way to distinguish the smell of hemp from marijuana. So that's where the issue is lying here. The state submitted several other cases as examples. State v. Cisco out of Arizona, which was discussed earlier. And in that case, we submit that that case did not stand for the odor alone rule. In that case, officers caught a whiff of marijuana while they were at a warehouse outside of a storage container. And given the facts of their investigation, where they were when they smelled that smell, those facts indicated that the odor of marijuana that they were getting was not coming from a use of marijuana that was compliant with the Medical Marijuana Act that was enacted in Arizona. And so basically a totality of circumstances test was applied in that case. The other states submitted by opposing counsel in this matter are intermediate appellate court cases from other states. And I would just urge the court to recall that the odor alone rule in North Carolina is rooted in State v. Greenwood, and the factual landscape has changed around that rule. Because of that, we ask for totality of circumstances test to be applied here. In this case, none of the other factors observed by officers tended to show that what they were smelling was illegal marijuana as opposed to legal hemp. Officers cited that this was in a high crime area. The facts of this case show that Mr. Rowdy was driving when they spotted a traffic infraction. They pulled him over, and he happened to pull over near the West Wall apartments, and he was not connected with those apartments, that high crime area, in any known way under the facts. They point to Mr. Rowdy not immediately pulling over, and they point to him purportedly blading during the interaction, but the facts there show that Mr. Rowdy was on a cell phone call while officers were questioning him outside of the vehicle, and he made a slight turn away from officers to complete the phone call, and that was the interaction that they described as blading.
Well, just to clarify on the application of the totality of circumstances test to the facts of this case, the Court of Appeals, in essence, took a two-step analysis. First, whether there was reasonable suspicion for the Terry frisk, and then whether there was probable cause for the search. And it seems to me, unlike the other cases, particularly on that second step, there actually are a lot more facts that would support, in the totality of the circumstances, probable cause. In other words, if we assume that there was reasonable suspicion, which is an even lower hurdle, right, for the Terry frisk, and then the officers find a blunt in his pocket, isn't that even greater sort of circumstances that would permit the search in this case?
Well, the recovery was of the supposed blunt in this case, which we don't know if that's illegal marijuana or legal hemp. And so we would submit that having that without knowledge as to whether this is legal hemp or illegal marijuana does not tend to push the ball towards probable cause in this matter. Officers can ask if this substance was bought in a store.
But isn't the point that, so when they do the Terry frisk, that's for officer safety. They just need reasonable suspicion that they need to pat down this suspect and make sure that the officers aren't in any danger. And so the trial court did make findings that he didn't pull over right away, and that he was, the trial court made a finding. I realize you're saying there's an explanation for this, but that he was turning himself away so the officers couldn't entirely see what he was doing or what he was holding or that sort of thing. Why isn't that enough to say, for the officers to say, we need to pat you down now for our protection as we're having this interaction with you? And your client isn't, one thing that stood out to me, your client is not arguing is that it went past Terry to reach in and take the blunt out. I mean, the officer admitted he knew it wasn't a weapon, but that's not before us. So wouldn't that be reasonable suspicion? It's kind of an alternative ground to get you to, because once you then recover what appears to be contraband, you're sort of in a different scenario.
Well, we submit those factors did not amount to reasonable suspicion for the Terry frisk at that time. And then the recovery of the blunt, the supposed blunt, doesn't bring the ball any closer to probable cause for the search that happened afterward. Thank you, Your Honors. For those reasons, I ask that you reverse the opinion of the Court of Appeals. Thank you.
Thank you, counsel. We hear from the appellee.
Mr. Chief Justice, and may it please the court. I'm going to address just a couple of points and then answer, hopefully, some of the specific questions that some of you had, and then answer some more questions that you may have. The first issue that I'd like to address, the first point that I'd like to address is actually raised by Justice Searles and to a certain extent Justice Dietz, and that is in its written order, in addition to the presence of the odor of marijuana, the trial court specifically relied upon the following in support of its denial of the motion to suppress. I'm just going to read from the written order itself. It says the failure of defendant to immediately heed the blue lights and siren of Bogus and immediately pull over rather than driving into the West Wall apartment complex. Number two, the fact that in the experience of both Bogus and Deputy Mitchell, the area of West Wall apartments is a high crime area. Number three, prior narcotics and carrying a concealed gun convictions of the defendant, which were discovered by Bogus during his search for any outstanding warrants, and the defendant's blading or turning and angling of his body. And those findings were supported by competent evidence, and I believe all of them, except maybe number four, were not challenged either at the trial court level or on appeal, and therefore are deemed to be supported by competent evidence and are binding on appeal. So, Your Honors, there is enough evidence in this case, in addition to the odor of marijuana, to rule either affirm the Court of Appeals or and not reach the constitutional issue, or to dismiss the case, ruling that the grant of discretionary review was improvidently allowed. When it comes to the actual issue of what standard to apply, I think all of us have kind of correctly abbreviated it to whether the odor of marijuana alone gives rise to probable cause of a commission of a crime. And so the question here, at least in this case, is in 2020, as these officers approached this vehicle after a lawful vehicle stop and smelled the odor of marijuana, both of them did, would that alone give rise to probable cause? I mean, I think that's the question that this court has granted discretionary review on. And so the question is there a fair probability that there was either more marijuana or the commission of a crime, which is what the court's issue stated. And the state obviously submits that yes, when we're talking about a traffic stop and we're talking about the odor of marijuana, yes, that gives rise to a fair probability that criminal activity is conducted. And I want to pick up on a couple of points of Justice Berger. The first one is that the way hemp is regulated, first of all, in 2020, it was pretty strictly regulated. There were certain guidelines and requirements, and it was focused, the Industrial Hemp Act, at least in North Carolina, was focused on cultivation of hemp as a crop for sale for purposes other than use, manufacturing purposes other than use. But as Justice Berger alluded to, the way hemp is regulated back then and now, it is, the psychoactive effect is less than 0.03% THC. And that is not enough to give you a psychoactive effect, unless you're smoking a lot of it. And I would assume that you might be very sick after doing that. The other thing is that Justice Berger pointed out, and I pointed out in my brief, is this is more like a situation where you have a pint or a glass of beer. And I think there's a pretty good probability that pint or glass of beer is alcoholic. It's possible that it's non-alcoholic, but there is a fair probability that it is alcoholic. And that brings me to the cases the Supreme Court has said, an officer can have a mistake of fact or even a mistake of law as long as that mistake is reasonable at the time. And there are cases also that articulate that that there are even innocent acts can create probable cause, and that's because the limit of the test for probable cause is extremely low.
Can I ask you, you mentioned earlier that this would be for traffic stop, that you're arguing that the odor alone principle to establish probable cause that a crime is being committed applies to traffic stops. But what is the principled reason why it would apply only to traffic stops and not stopping pedestrians on the street, people sitting on a bench, someone who answers the door at their home? Why, if the odor, if what we're holding as a matter of law, as you seem to be asking us to do, that the odor alone gives probable cause that the crime of possessing illegal marijuana has been committed, what's the principled reason why it only applies to traffic stops?
Well, the principal reason why a traffic stop is a little bit different is because that's an exception that the Supreme Court has created to the Fourth Amendment prohibition against search and seizure, that a warrantless search is actually able to be conducted at a traffic stop if the officer has probable cause. So that's an exception. So that applies to that. If it's in a home, then they would have to get a warrant, presumably, in order to search the home.
And what about pedestrians? In
pedestrians, I think that's where reasonable suspicion comes in, which is a lower standard even than probable cause. Now, one of the things I want to point out, and Justice Dietz kind of alluded to this, or maybe it was you, Justice Shirtle, I apologize. In this case, the reasonable suspicion was a bit of a red herring. And in fact, the Court of Appeals stated, we do not deem it necessary to consider defendant's arguments concerning the blunt as the search of defendant's vehicle was lawful and supported by probable cause without the discovery of the blunt. The odor of marijuana emanating from the vehicle provided probable cause. So I would contend, and that's not before us today, it's not been briefed and is not what you are considering today, but I would contend that reasonable suspicion would apply to the case of a pedestrian, and the odor of marijuana would still give rise to reasonable suspicion. Also, in answer to your...
What I hear you saying, I heard you advocate for kind of the existing per se rule that the Court of Appeals has articulated. But then when I hear you describe the standard, it sounds to me like totality of the circumstances. So when you used the analogy with Justice Berger and the alcohol, you need to know the circumstances in order to make that determination. So for example, if the officer saw the person walk out of a little pub-looking area with the glass and it looks like Guinness, but the sign on the top of the door says, for recovering alcoholics, we serve non-alcoholic drinks only. I don't think there would be probable cause there to think it was an open container, whatever it was. And so in other words, you really always are looking at the circumstances in which you smelled the odor. What else is going on around you? And if we just adopted that as the test, that seems consistent with what the Supreme Court of the United States has said. And there will be many circumstances in which the officer says, given everything, the circumstances around where I smell this odor, it's probable cause. But there will also be sometimes where it's not. What's wrong with that?
That's where the analogy to the non-alcoholic beer may break down. But the odor of cannabis is a distinctive odor, and for the most part, it is marijuana. And in that circumstance, we would urge.
So if an officer's following a suspect and goes into one of these stores that sells hemp and smells the odor in there, it is probable cause?
Your Honor, I think that's a little bit far, not before us.
Well, I just wonder if maybe the way to just harmonize all these hypotheticals is just to acknowledge that it's a totality of the circumstances test. And there are going to be circumstances where maybe the odor alone, with sort of just where physically are you, what's going on around you is enough, but there could be also times when it's not.
Well, one of the things that I forgot to mention is that, we are also talking about the officers being trained in drug identification, which they were in this case. I would contend that the odor of marijuana gives rise for probable cause. That's the state's position. I understand that you're making a very, I don't want to call it argument ad absurdum, but a pretty extensive argument. But that is not the case before us, and it's not being adjudicated to my understanding today. So the other thing that I wanted to address, Justice Behringer, you mentioned the state of Arizona as kind of adopting odor of marijuana is probable cause unless, and I went back and read that case, and I think it does. It did, however, the Arizona Supreme Court did reject the odor plus test that was suggested by the defendant in the appellate court. So it obviously rejected, if it rejected the odor plus, it rejected the totality of circumstances. So I think your characterization is probably appropriate. The odor of marijuana does cause, in Arizona at least, does create probable cause unless there are other circumstances which would lead a person to believe that there are not.
And how do you, I certainly understand the medical marijuana card, but how do you respond to, I believe it was Justice Allen raised the issue of having a receipt, perhaps not actually seeing someone come out of one of these stores, but a receipt to that extent. How would you see that either in an unless situation or a plus situation?
Well, one of the distinctions is that marijuana is still illegal. Back in 2020, the definition of marijuana was over 0.03, but marijuana is still illegal, and as my colleague argued, that would create an incentive for a suspect to pull up a bag and pull up the the receipt and say, hey, you know, it's legal. What we're looking back at is whether there's a fair probability that that criminal activity has occurred or is occurring. And when you're talking about a traffic stop, I think that that creates a fair probability, regardless of whether they have a receipt or a package bag. I believe that's all the questions that I believe I have specifically answered. I'm happy to answer any other questions.
What if we, suppose we said, well, the standard is totality of the circumstances. It has to be, because that's what the U.S. Supreme Court has said. But then we went on to say that ordinarily, in the context of a traffic stop, the smell of, or the odor of marijuana will provide probable cause. Well, what would be wrong with that?
Well, Your Honor, in the context of a traffic stop, what we're doing is we're asking police officers or deputy sheriffs or whoever to walk up to a vehicle that they have legally stopped and make a determination whether there is probable cause to search. And so when you say ordinarily, then you're creating a situation where it may not occur. And so we want the bright line. The way I kind of look at it is not, the Venn diagram's probably pretty bad analogy, but it's a Venn diagram where the circle is totality of the circumstances. But within that circle, we have a bright yellow circle that says odor of marijuana. And what the state would urge is that that is the standard, has been the standard, and remains the standard, such that in situations like this, the officer does not have to make calculations in his head. If he smells the odor of marijuana emanating from the vehicle when he lawfully stops vehicle, then he should have probable cause. He has a fair probability that criminal activity is happening and therefore is able to search the vehicle. That concludes my presentation. Thank you.
Thank you, counsel. Rebuttal.
Your Honors, I would just submit that during that ordinary traffic stop situation, that officers are allowed to investigate further. And the issue here is clarifying whether this is illegal marijuana or legal hemp. And so the investigation can be towards asking questions or asking for a receipt to show, to prove what it is, the substances in the car. So for the reasons stated before, I just ask that this court use the totality of circumstances test here. Thank you.
Thank you, counsel. Mr. Clark.